My name is Bill Bay. I'm the chair of the section of litigation. We're here in my hometown of St. Louis. The section of litigation is proud to present as a wonderful plenary, baseball, a governor, and successful trial strategies. This meeting has been primarily about leadership and how we will position the section for the future. Yesterday's committee planning workshop was a fantastic event that literally had the room buzzing with new ideas. But we should also take some time to focus on our craft as trial lawyers and how we can do a better job of being a trial lawyer in the litigation and the clients we represent. The panel we have this morning assembles 3 of the top trial lawyers in America to talk about that craft. It gives me great pleasure to introduce today my good friend and one of my predecessors as chair of the section, Hillary Bass. She recently completed an 8-year term as the national chair of Greenberg Trauerig's 600-member litigation department. She serves as the global operating shareholder. Her ABA credentials literally fill a page, but around this group she will also be known, always be known, as one of the most active and accomplished chairs of the section. She's a superb practicing lawyer, a fellow of the American College of Trial Lawyers. I don't know whether she will moderate or referee the discussion today, but we're really honored to have all 3 of these people, and she is going to introduce the 2 panelists. Thank you.
Thank you, Bill. Good morning. Rod Blagojevich, Illinois Governor, 2 criminal trials on claims related to extortion, the best known of which was a claim that the governor attempted to get personal consideration in exchange for appointing President Obama's successor for the Illinois Senate. Roger Clemens, baseball legend, makes the unorthodox decision to testify before Congress, asserts that he never used performing-enhancing drugs, and is eventually indicted for perjury and has to go through a criminal trial. These 2 trials are 2 of the most widely publicized public trials in the last 10 years. And we are very pleased today to have the 2 lawyers who were involved in both of those trials. Sam Adams Jr., along with his father, Sam Adams Sr., defended Governor Blagojevich in his first trial, which led to the governor being found guilty on 1 count and deadlocked the jury on 23. Sam was not involved in the second trial, in which the governor was found guilty of a few more. Sam graduated from the University of Wisconsin Law School and went on to obtain scores of acquittals for criminal defendants, including R.J. Kelly on his pornography charge, and non-guilty verdicts on multiple defendants who were being tried for murder. He's considered one of the top 100 trial lawyers in the United States. Thank you, Sam, for joining us today.
Thank you. Thank you.
After Roger Clemens made the unusual decision to voluntarily testify before Congress and was then indicted for perjury, he found Rusty Hardin to defend him, and Rusty was successful in getting Roger off on all charges. Rusty attended SMU Law School and then was an assistant district attorney in Houston. Since he's been in private practice, he's had more than 70 criminal and civil trials. He's best known throughout Texas as being one of the top Texas trial lawyers and was also the chief trial counsel in the Whitewater investigation in Washington. We are very pleased to have you with us as well, Rusty. I'll start today by quoting from Robert Shapiro, who before the O.J. Simpson trial was quoted as saying, "There's no question that media coverage can and does affect the ultimate outcome of widely publicized cases." So I'll start by asking whether you agree that your relationships with the press are as important as your relationships with the judges and with the prosecutors. And if that's the case, how do you develop a media strategy for a publicly well-publicized trial?
First of all, I'd like to say thank you, and it really is an honor, absolute honor to be here. And I will apologize if I sound a little nervous, because I am. When I looked up these 2, one to my right, to my left, and realized God had retained them on occasion, I did not belong on the stage with them. But to answer the question as truthfully as we can, I believe that the media and the relationship with lawyers very many times can be a positive for your client, especially in criminal defense. However, you have to take it and look at the client that you have, the facts and circumstances of the case, and determine whether or not you have anything to gain by using the media as a tool. With Governor Blagojevich, I certainly took that tack because I remember December 9th of 2008 when I watched him get arrested, and then I saw the press conference by Patrick Fitzgerald, the U.S. attorney at the time, who said that Lincoln was going to roll over in his grave, and said that. I looked at the TV and go, God, man, Blagojevich, what a scumbag, you know? And then, because that's what the media attention had done, and by the end of that day, he had a 0% rating, which means people in his family didn't like him anymore. And so we took the attitude that the only way we're going to be able to turn this thing around would be to have him come out here. He's been a public speaker his entire life, to have the media attention that was just going to be there no matter what happened, and try to just get back to even when the most respected, or second most from Ken Starr, second most under Ken Starr, respected prosecutor in the country, calls your client worse, you know, Lincoln would roll over his grave, and worse than New Orleans, no offense to who was just standing here, but what do you do? And so we got a media campaign, and if anyone who has represented a politician will know, the only word better than Jesus is polls, and so he was polling everything. And by the time we started trial with that, him going on The Apprentice, his wife eating spiders in Costa Rica for him, we had gotten back to 50%. People had said either A, he's totally innocent because nobody would go on like this, he's absolutely innocent and when he says it is true, or B, he's absolutely crazy. Either way, to a defense lawyer, that's either not guilty or not guilty by reason of insanity. I'll take it. And so I think you can use the media as a tool. Lastly, before Mr. Hardin takes it, but you got to look at your facts as well. When you have a case in which 2 women are murdered by a police officer in Bolingbrook, or at least allege that, you can't go out in media and start making fun of those facts like what happened in the Drew Peterson case, in my opinion. You have to take a look at your client, your facts, and then decide how are you going to use the media as a tool if you're going to do it.
You know that that the years are catching up with you when an accomplished lawyer is sitting next to you and calls you Mr., okay? You know, our relationship with the media and Roger Clemens was disastrous, and the reason was that there wasn't an investigation. It all resulted, when they first came out, the equivalent of an indictment was the Mitchell Report. And when the Mitchell Report came out on December the 13th of 2007, a date blazing in my mind, Roger Clemens could never get out ahead of that story from then on. And I didn't realize that at the time, but even so, he had a national reputation and a professional reputation that was just totally destroyed. Probably after the Mitchell Report, if you took a poll, about 95% of the American public believed he used steroids and HGH. The problem with all of this is in using the media, and I don't really like the word using the media, because I think once it becomes apparent that's what you're doing, you lose that battle. But having a media strategy depends upon, do they have a public reputation? Do they have a public image that is just as important to them, perhaps, as their own legal status? One of the things we forget sometimes as lawyers is that our natural inclination, when we've got somebody that is accused of something, and my practice now is about 90% civil, so I'm only in and out of the criminal justice system the last 8 or 9 years. And in Rogers, it lasted 4.5 years. We didn't talk to the media at all after the first year. Very rarely we didn't talk to the media after the referral to Congress. Once he was referred to Congress to be studied for whether he was going to be charged with perjury, then we just stopped. And that was another 3.5 years. But we never, ever got out in front of that story. He started out with, and I'll tell you real quickly, because it sort of dovetails to what I think Hillary's going to ask in a few minutes about Roger's decision to testify before Congress. All he was ever doing publicly was just saying he didn't commit a crime. We had a trial that the world watched that was based on the proposition of a man is being tried for denying he committed a crime. That's really all it was. And he tried to say that repeatedly, and it just never got out front. I did not have an appreciation. Part of the deal is, and I don't know Chicago media well enough to know, and it'd be helpful to know to me, just personally. What I had never done is had a case in which the tabloids were involved. In Houston, we really don't have a head-hunting media. And so I had never dealt with the media that had an agenda. I'd represented a lot of public people, but for some reason they were always covered by the mainstream media, which has rules, and which I like. In 37 years, I have never been misquoted. I've been quoted saying some things I wished I hadn't said. But I did say them. And then the second part of the media I was unprepared for was the sports media. They are not true reporters. They're entertainers. And I didn't appreciate that. And I had to learn it afterwards. So what happens is, I mean, I have people with ESPN saying, I'll say, you know, if you check out so-and-so, you find out that's not true. I don't care whether it's true or not. It's just whether somebody said it. Well, that's a new set of rules for me. And so the combination of tabloid, the New York Daily News, and the New York Post were in a competition. They were all pissed because Roger went to Houston after he retired from New York, and they never forgave him. And so they played to that audience in New York, and so they had an agenda. Well, when you have a media that has an agenda, you just need to buckle down and leave it alone. There is nothing you can do. And I didn't appreciate that. So I have always said that I did a horrible job with the media in the Clemens case, and a lot of it was out of ignorance. But the second thing is you couldn't have done anything to change. Finally, Hillary, all I'll say is mine was a little bit different. I always thought the only chance Roger Clemens ever had to maybe get people back to 50-50, and I don't even know whether we have him back that far even now after he was found not guilty, was to have a trial. So everything we did was designed to have a trial. We had a civil lawsuit because I thought that the only way we would ever be able to challenge the accusations is to have them in a courtroom in which we had the opportunity to cross-examine and deal with them. There was going to be no other way to deal with that case. But once he was referred to Congress, then we just shut up. And then we got a gag order. And the final thing I'll mention is that the gag orders are not always bad. If everybody in the accomplished world is calling your guy bad names, then a gag order doesn't necessarily hurt the defendant. In this case, the only problem is I didn't get a chance to respond to Araldo. Apparently, I didn't see it on a Friday afternoon, calls me the worst lawyer in America, and Monday the judge issues a gag order. And so I told the media off the record in Washington at a hearing, the only thing I hated about that was I didn't get to say, oh, he called me the worst lawyer in America? Well, where did he do that from? Al Capone's crypt? And I didn't get to do that. So anyway.
Well, when you're developing a media strategy, and Sam, I'm particularly interested in your reaction to this. Who is it attempting to influence? Are you attempting to influence the public, the judge, the jury veneer, or just media in general?
Well, seeing as the ABA talks about ethics, I'm going to temper my comments because I will not say that I'm going after potential jurors. I won't say that. But
you were actually quoted as saying that at one point, weren't you?
Like he said, the media doesn't always get it right. Actually, well, that's a very good answer. And the truth of the matter is in Chicago, and we do have a media with definite bias and definite agenda, especially when it was Governor Blagojevich. Before he was ever arrested, his approval rating was at 13. And so he was not a well-liked, even though I think he did a lot of things. And like I said, when I first saw him arrested, I had terrible things till I got in the case and saw this really wasn't what people were saying. And we had to get out in front of that. So the ultimate answer to your question is, of course you have in the back of your mind, I don't know who the 12 people are going to be that are judging him. I know this. I know that if his approval rating is 0, those 12 people are going to come in there and think he's guilty from the start. And so what I have to do, if you can, is try to build back that steam. Try to get out before the public, because you don't know who those 12 people are going to be, the facts that help your client. And in our particular case, one of the things that I think what was missed at first, but then it came on, is when he was on national television saying, look, they taped 428 hours of me. They taped me. They have now put a gag order on the tapes. There's a protective order on the tapes. Let me play them. We did an impeachment. I came very close to St. Louis and Springfield and did an entire impeachment, which we asked for the tapes. Now, I knew, because I had heard them, that there was some very good exculpatory stuff on those tapes. They would never release it. To this day, the only thing that's ever been allowed to be played is what the government played in 1 hour of what we asked for. And there's still a protective order on the tape. So that should tell people, if they're still, and the jury's gone and he's doing 14 years, what I'm telling you is true. And so we wanted potential jurors, of course. We wanted the public to be out here and saying these things. How can you tape a man for 428 hours and not allow him to play what you taped? And it started to build and build and build. And so, yes, when I did make the comment that I was talking to the jury, that was right after we hung on 23 of the 24 counts. And I was angry. I really was angry. And what I told right there at the media, I said, if anyone wants to blame anybody for that one conviction that we have, blame me. I was the lead lawyer. I was the one that should have convinced them better. I am talking to the next jury. When you sit, don't consider that conviction against him. It was my fault. I should have done a better job. And I meant that. I still mean that. I know that in 23 or 24 in federal court, people say, well, that's great. I look at it as kind of like baseball. Tie goes to the runner. But I wasn't running. I should have won. I should have won all those counts. And that's what I meant by talking to the jury. They shouldn't hold it against him. Hold it against me.
I think I'm more talking to the public at large because of the client's reputation than I am a jury or a judge. Judges don't like it, first of all, so I'm certainly not talking to them. And I'm not going to persuade them by anything I say publicly, obviously. I'm more interested in trying to balance out this person, this man or woman's public reputation that's very important to them because of what they've spent their career doing or what their position is if they're a public official or so. I don't believe in talking about what the evidence is going to be. I really, you know, I've always said I have 3 rules about dealing with the media. Always return their calls. Always tell them the truth. And when you can't talk to them, explain to them why you can't. Now, if I get off to the tabloid where people I can't trust, then I can't do that. But if it's the regular mainstream media and not the blogs or the other things, you try to explain to them why. Look, I can't do it for XYZ reason right now, but you try to give them your story. You need to always make sure the media, whether you're talking to them public or not, knows and understands your client's side. And you have to get out front right away. If you wait, never forget the newspaper morgue. And what I mean by that is that when those initial stories come out, and then subsequent stories come as the case develops, they will always end up their articles with going back and recapping what has been said before as a way of ending up. Those are what I mean by things in the newspaper morgue. And so if you never had a beginning version for you and your client, then they're only recapping the other side's version when they come back at the end of subsequent articles. So you have to get your side out right away. Then the question is how often you talk to them. If I'm a judge and the lawyer's doing a lot of talking, I'm going to get tired of that, and I'm going to call them in. But I think most judges hopefully understand with a public person, if the government, if it's a criminal case, is going to announce how horrible your client is in front of the American eagle and the American flag, and run through all of these speaking indictments, then the defendant's got to have an opportunity to respond. The question is, how does he or she continue to respond? And if you start talking about witness X is going to say so-and-so and witness Y is going to say so-and-so, I don't think that's appropriate. I think that is trying the case in the media as to the facts. I had one, but you need to, always remember when dealing with the government, they do not have a sense of humor. And I was part of the government until I was 49, so I don't feel like a stranger, but I'll give you one quick example. Is when I represented Arthur Anderson back in 2002 and they were indicted, all I said to the media is, for anybody that would listen, we are not guilty. And we're going to have a speedy trial, and I'm comfortable that when everybody hears the evidence, the people will agree we're not guilty. So all I was saying is not guilty. I get this letter from the head of the Enron task force that gives with a 5 or 6 page brief about the canon of ethics and speaking to the media. Now remember, we're only saying we're not guilty, which theoretically there's still a presumption of innocence that really shouldn't be biasing people by say you didn't commit a crime. So I write back, and then I was talked out of it by Davis Polk and Mayor Brown lawyers that were wonderful lawyers working with me, were a little bit more cautious about things they would say to the government. I wrote him back and said, "Dear so-and-so, I thought you would like to know that some idiot is writing me letters and signing your name." And since he is using official Department of Justice stationery, you might want to begin an investigation. Sincerely. I didn't send it.
Sam, I'm curious, when you are engaged in a significant media strategy, how do you handle the limits? I know that in your case, the one time the prosecution went to seek a gag order unsuccessfully against you was when you were commenting about a prior witness who you asserted had lied. So how do you try and evaluate how far you can go?
Well, I have to say, Rusty.
Thank you.
I have to say he's right, and we did not. If anybody goes back and look at the media stuff, we drew the line at talking about what the evidence was. We typically just said he's innocent, we want to play the tapes, we know that he hasn't done these things, that kind of a thing. And then during trial, the government tried to have a gag order placed on us. But we had the perfect storm when it comes to the media, and that was Patrick Fitzgerald's initial press conference, which he was not sanctioned, but at least spoke poorly about by the New York Times, by the LA Times, saying you shouldn't do these things. And so now a lot of people think that I stood up to Zagel, that was the judge during the case, and told him I'd go to jail because he wouldn't allow me to say that the witnesses hadn't come forward. And so I had a persona of being tough, but I really was not all that tough. I was scared to death. There's no doubt about it. And my father was the one that had, as Governor Blagojevich always used to use that term, the testicular fortitude. That's what he would always say. And so my father was the one, and they wrote a letter, much like what Rusty said. They wrote a letter to the judge saying we need a gag order on this. And so my father took an entire weekend and wrote out all of Patrick Fitzgerald's press conference, line by line by line, and said, if you're going to gag us, this is what you have to do. And I'll never forget this. At the bottom of the initial one, we didn't end up sending it. The bottom of the initial one, he said, I would like to quote from Cohen versus California, where a man was allowed to say, F the draft. If Cohen can say that, F the draft, allow me to make the same sentiments to Patrick Fitzgerald. And so, but his point was, that's the First Amendment. We have a right to get out here and do these things. We never ended up sending that letter, but the judge heard it and denied the motion because it was so patently unfair that the most recognized U.S. attorney in the country at the time made these comments. We were allowed to come out. We limited from that moment on, not talking about witnesses until they had fully given their testimony, fully said anything, because I think Rusty's 100% right. It isn't appropriate to talk about the evidence, but certainly you must get out there if you have the right case to talk about the innocence of your client, because the culture is so dead against criminal defendants now that the only way that they ever hear you say not guilty is if you're able to be out in front of it. And that was one of the strategies that we had to employ in that, because nobody thought so when they watched him get arrested.
Once you roll out a media strategy, both of your clients were accustomed to dealing with the media on their own all the time. And obviously, Sam, you had a client that gave press conferences at the end of trial every day. How do you control a client who is potentially uncontrollable?
Well, in fairness to Rod, that's what we wanted. We had a guy, and this is true, we sat down and came up with a decision. We had a man that had given his entire life to public service. He was a congressman, then he became the governor of the state of Illinois for 8 years, and he really does, if anybody has ever watched him or seen him in person, he really does have this lovable, affable personality. I've had a number of people that I knew that hated him, hated his policies, couldn't stand him, and then I brought him over to the office and they met him, and they going, God, I love that guy. Holy cow, I love this guy. He couldn't have done it. And I'm saying, and I wanted people to see that. And so he really wasn't uncontrollable at all, because that was the strategy that we had. Now, I've had a couple, and I won't say by name. The way that I ended up handling them was I sat them down and I said, listen, either you do what you want to do because it's your case. And I think lawyers lose sight of that many times. They think it's their case. But it's not. It's your client's case. And I told him, if this is what you want to do, I'm fine. But you're not going to make me a part of it. Now, you either calm this down and be quiet, or I'm out of here. And they ended up coming along, and sometimes you have to make those threats.
Rusty, have you had those kind of issues with your clients with reference to them going to the media despite your...
No, I really haven't. In Roger's case, the perception of Roger always is that those who wanted to give me the benefit of the doubt, who all disagreed about him testifying before Congress, assumed that Roger had insisted on it, and I had a strong-willed personality client that wasn't following advice. And that was really based on his public persona as a ball player, because he was a very aggressive, focused, strong-willed ball player. He actually is one of the best clients I ever had. We never had a problem. He always followed his lawyer's advice. The decision that we'll probably get to in a minute about whether he should testify before Congress was not some bullheaded decision he made. And now we'll explain that in a few minutes. But the thing, I think the easiest way to control a client that you can't control is to fire him. Because, you know, I decided a long time ago, I was 49 before I went into private practice, and I decided when I did it, life was too short to represent jerks. And so I was defining jerks not in terms of whether they did something wrong or whether they were liable in the civil area or whatever, but solely whether or not they were a person that I liked trying to help. Now, if I was appointed to somebody that the system asked me to represent, that's a different deal. But when I'm representing somebody that is compensating me, I don't have to put up with somebody that will not listen to me and not follow my advice. So I don't have them very long, if I have them, but I can't really think of more than one or two in my career that have been that way. I think people sometimes tend to think the client's out of control because they don't agree with what the client is doing, but sometimes the client and the lawyer are doing it together, and we just sort of aren't willing to assume that.
Well, let me ask you this question, Rusty, because it has been reported that perhaps your comments about the Mitchell report may have inflamed the prosecutors and incentivized them to bring an indictment against your client.
Yeah, not the prosecutors. Remember, the prosecutors weren't involved until the case was referred over to the Department of Justice, who then referred it to the U.S. Attorney's Office because the top two people in the Department of Justice had to recuse himself from Clemens' case. Because Lanny Brewer, chief of the criminal division, had worked with me in defending Roger before Congress. And because he and Eric Holder came out of the same law firm, Eric Holder had to recuse himself too. So they sent it over to the U.S. Attorney's Office rather than being handled by the Department of Justice. You know, it's an interesting concept. If a report that is published is a lie and totally ruins your client's reputation, to suggest calling it that and criticizing it somehow is going to get your client indicted is a hell of a comment. There are people who said that. But the track is, I will tell you real quickly what Roger Clemens always knew. And I want every lawyer here to just think about it and tell me what you would advise your client, because it really goes to the heart of what we do a lot. The report, as I mentioned, comes out December 13th, 2007. Originally, George Mitchell, it was believed, was not going to name names in the report. They were going to study steroids and HGH in baseball, issue a report. Baseball players uniformly, agents and lawyers throughout the country, told him not to cooperate in terms of go down. He wanted to interview ball players. He wouldn't tell them what he was going to interview them about other than the general topic. Wouldn't talk about what evidence was against him. Remember this. The Mitchell report is a report by a private law firm, DLA Piper, on behalf of a private organization, Major League Baseball, about whether the employees of that private company are engaging in misconduct as to HGH and drugs. That's what it was. The employees, lawyers, and agents decided it wasn't to their advantage to be interviewed because they wouldn't tell them what the rules were and what was going to happen. So Mitchell decides to publish the names, but we didn't know for sure that he was going to use names. So on December the 12th in my office, I tell Roger the following things. And so he had to consider this, and you as lawyers would have to consider this. Roger, if this report comes out tomorrow and says that you, and we've been told a week before for the first time what the allegations were by this guy McNamee. If this report names you, here's what's going to happen. Waxman is going to offer you an opportunity to testify before Congress, because this report is the vested product of Congress. It was a deal between Major League Baseball and Waxman and his committee. If you will commission an independent study, and by the way, my good friend George Mitchell would be a good person to be chairman of this investigative deal. If you have an independent report, then we're not going to muck around in your antitrust exemption. But if you guys don't do this independent investigation, then we're going to start re-looking again at this antitrust exemption. So baseball and Congress are together on it, private group for private company. So I say, and then I and everybody's going to tell you, voluntarily, you don't want to go up there. I've only seen one good witness before Congress in my career, and he wore a Marine uniform and told him to stick it where the sun doesn't shine and had immunity, so he could say whatever he wanted. But other than him, I've never seen anybody do any good in front of those Klieg lights. So we would say that's not a good idea. Then they would give you two choices. Because in 2005, when they had that group up there where Sammy Sosa didn't speak English and Mark McGuire didn't want to talk about the past, they were all subpoenaed. So you're going to get subpoenaed if you voluntarily, if you say you're not coming voluntarily. And then when they subpoena you, you're going to have only two choices. You take the fifth, you are home free. These allegations are outside the statute of limitations, but more importantly than that, they're not prosecuting anybody for using these things. So you're home free if you take the fifth. But everybody will think I did it. Yes, but your legal position will be safe for the rest of your life, and you move on your life. If you decide that you don't want to take the fifth, and you testify before Congress. Now, we're telling you this the night before the report comes out, before there are any referrals or anything. If you testify under oath you didn't do it, you're going to be referred to the Department of Justice by Waxman for perjury, and the Department of Justice will probably indict you because the prosecutors won't have the courage not to in light of all the publicity that's going to be around it. So, but I can't take the fifth. I can't let people think that I didn't do it, that I did it. And so we went along and talked. So at the end of the day, Roger Clemens testified before Congress, and his lawyer did not try to talk him out of it because he was not willing to take the Fifth Amendment when asked publicly whether or not he had used steroids and HGH. And we had a whole trial because a person was not willing to exercise his Fifth Amendment right.
Well, obviously, the decision of whether a defendant testifies is always one of the most important. So, Sam, I ask you this question. You made the decision not to put on any defense in the trial that you handled for the governor, but you did talk about in opening the fact that he was going to testify. So let us know, how do you balance those issues when you don't know, obviously, at the beginning of the case whether or not your witness is actually going to go on the stand?
Well, if you recall... would you mind, Ms. Bass? Is that okay? All right. If you recall, when I first took the phone call from you, I told you that I was very happy and honored to be here as long as I could tell the truth. You said tell the truth, so I'm just going to, I know it's streaming live. I hope the judge isn't watching. What happened here was we spent the first year and a half telling the entire country, actually internationally, he wanted to testify, he would play the tapes, we want to testify and all that. And this is the honest-to-goodness truth. I meant it. We had prepped him. My father and I spent about a month and a half right before trial and then the 3 weeks during trial before he was supposed to hit the stand, prepping him in a park. The reason we prepped him in a park was we figured the feds had recorded my office, had put spike mics in. If you recall, my office, and I don't know if anybody followed this at all, my office actually had been broken into at about 4 or 5 months before trial, and we just naturally assumed, and maybe, you know, they say paranoias are right half the time or sometimes, and we were just paranoid about that. So we literally prepped him in a park in Chicago. And it was really strange because people would walk by and go, that's Governor Blagojevich, what's he doing in the park? And we wanted him to testify, knew it, believed it. And then as the trial started going on, and if anybody followed this at all, the first, after opening statement, there were pieces in the press. Holy cow, maybe he didn't do this. And then after the first witness, which was Governor Blagojevich's right-hand man, and knock on wood, I had crossed him and had done a competent job of crossing him. And the paper came out, holy cow. And this is one of the things that the guy said right there on the stand. I asked him, I said, you took cash from Tony Resco, didn't you? Yes. But you never told the governor about any of that cash. You never gave him any of that cash, did you? No. Why not? He said, because the governor would have never allowed it. He would have been upset that I was taking bribes. Now, you know, honestly, I didn't expect that great of an answer. You know, and so, you know, nothing further. And the paper, and this is true, this is exactly how it went. The paper started writing, holy cow, governor's right-hand man doesn't take cash, governor won't allow it, what's going on, why would they prosecute it? And from that moment on, the judge in the case hammered us down. The next witness was my father's witness, 164 objections made by the state to one witness in a day of cross-examination, 162 sustained. This is true. I actually have this quote. Mr. Adam, my father's done it 51 years. Mr. Adam Ask a non-leading question. There's no leading questions here. And my dad looks at him and says, well, this is cross. Move on, Mr. Adam. No leading questions on cross. And so I'm not, you think I'm joking. I got it. I'm telling you, I got this. And so it was hammered. I mean, the very next witness I took, Aliata, I'll never forget this. He was cooperating with the government, and he was an Arab man, and he had been accused of and proven not guilty of al-Qaeda ties or something like that. And I wanted to show and bring out from him the reason you're cooperating with the government is because you're a true American, a real American, the kind of guy that, that if they put pressure on you, you'll fold because you want everybody to know what kind of American you are. And so I simply asked him, you were not doing anything illegal with that other stuff that you were accused of. Objection, take the jury out. Mr. Adam, you know better than to ask that. I said, ask if he didn't commit a crime? Are you kidding me? And no, hammered us. And so to make a long story longer, what ended up happening was right before governor was going to take the stand, and we had prepped him, ready to go, and this is a man who spent his time talking. The judge made the mistake, and he said, because the government doesn't have the opportunity to call him as a witness, I'm going to give much more latitude to them than I was giving the defense because they can always call those other witnesses back. And it hit us. He's going to let them ask if he cheated on an 8th grade math test, the government was going to be able to do it. And my father and I spent the weekend. Now, this is true. And, all right, I said I was going to tell the truth. I tell the truth. And we decided if we don't put him up, we lose credibility with the jury. If we do put him up and the judge lets him get into whatever else, he's dead because there's, with 404B evidence, they don't even have to tell you until they do it. We said, that's it. We can't put him up. How do we get around this? And my dad said, this is what we'll do. Now, jurors are not to look at media, and I don't think they do. But if they do, we had decided that my father and I were going to have a public debate. And I was angry because I wanted him to testify, and my father was upset because he wasn't going to let him testify. And the media picked it up, and in fact, the closing day was Sam and son fight. Son wants to put him on. Son demands to put him on. Father won't let it happen. And the very next day, my father came in there and stood up, and he had only done one witness, and he stood up and he says, I have overruled my son. He wants to put the governor on, but I have overruled him. He's not going on the stand. And from that moment on, I could tell the jury in closing, I wanted to put him on, but he wouldn't let me. And so that's what happened.
Rusty, have you had circumstances where you've told a jury in opening that they're going to hear from the defendant and then made the decision not to put him on?
No. I mean, I totally sympathize with this. By the way, I really do think Sam needs to work on having a little more passion, don't you? I wish more lawyers had that kind of passion, quite frankly. I love it. I think what Roger's case did crystallize for me, though, is the thing that we give lip service to, but people are very cynical about a lot of times. And the assumption always is if a defendant doesn't testify, it must be because he's guilty and the lawyers don't want him subjected. And that is true a lot of times. As a prosecutor, I used to say the 8 most beautiful words in the English language were, Your Honor, when the defendant stands up or his attorney stands up and says, Your Honor, we call the defendant to the stand. And that was to me always, as when I was a prosecutor, the most precious thing that could happen at a trial. So there is a lot of truth to that in some cases. But I think most of us now, if we've done it a while, realize that old saying that some people who are innocent are right about something are still not good witnesses. And we had watched Roger before Congress, and we never thought that we would put him on the stand. But the reason is there's a speech pattern with him, and the reporters used to tell me later, I don't know why you're surprised, and that was when I said the problem with Roger when you asked him a question, although I saw an interview with him today with a few weeks ago with no handlers, no PR people around, and he answered all the questions. But Roger tended to answer what he thought you meant and wanted to know about the subject, what he wanted to say, rather than the question. Well, of course, when you're dealing with a witness on the stand on cross, it's disastrous. And in our trial, they had, and by the way, just to go back one side, I want to make sure people understand, we tried to talk them out of calling him before Congress. It's just that when they gave us no choice, we were there. We went up and begged them not to have the hearings, not to have it. So it's not like we were wanting to be there. It was only a last ditch where we had no choice. Having said that, when Roger testified, he had already given a deposition the week before. They'd taken the deposition the staff had of Roger, of Andy Pettit, and of the main accuser, Brian McNamee. And that was, we had audio tapes for that. The government did. Congress didn't want to give them to us. They kept talking about the speech and debate clause. If I ever get off on that institution as an institution, I'm not really anti-politician, but I'll tell you what, that investigative committee stinks. That whole process, the way they abuse citizens, stinks. With potted plants never able to do a thing about it. But having said, what happened is in the deposition on the audios, the judge helped us. He finally shamed the House into turning loose the audio tapes of the depositions. And the reason I wanted them is we'd been there. We didn't do any questioning but I believed, and the jury later confirmed it was true as far as they were concerned, that if they could hear his voice in the deposition, trying to help the questioner. He would go on for as a lawyer, it'd make you nervous as hell because he talked for 4 pages on a deposition thing in one answer. But you could tell he was really trying to just think of any and everything he could to help him with that answer. And I believe they would not think that was someone who was obstructing and trying to lie and mislead Congress. And the first bit of evidence the jury asked for, so for each obstructive act, without telling you how to build a Swiss village, when you really may not even want to know what time it is, the deal was that they had, the first count was 18 or so, I've forgotten the number now, obstructive acts. Any one of those obstructive acts, if he was found to be unanimously to have done that, would have been enough to have him convicted of a felony on that alone. So all of those excerpts, they were introducing the video of him testifying before Congress, or the transcript or the audio of him giving it in the deposition. And most of the obstructive acts they were challenging him with occurred in the deposition, the non-videotape part. The first bit of evidence the jury asked for at the end of the trial was those audio tapes. And we talked to 5 or 6 of them afterwards. And they all said the same thing. You listen to those audio tapes, that's a guy that may not be artfully answering the question, but he clearly is not trying to lie because he just goes on. And then the government made a mistake of taking little abstracts and leaving out this and that, which makes them look in front of the jury like they're trying to mislead. So we didn't need to put him on, Hillary, and of course he was on trial for having been a bad witness. so why would we do it again? Okay.
Let me ask you about how you handle voir dire when you know that the entire veneer has probably been reading about your client and the allegations against your client for more than a year. How do you handle that, and did the judges in both of your cases really give you an opportunity to address those issues?
In Governor Blagojevich, we couldn't ask anything. In fact, they had gotten 600 people to come in, and the next day we show up, and 300 had been summarily dismissed. Don't ask me. I was just there. 300 had just been summarily dismissed. He said because of time constraints. The government had said that they were going to be about a 4-month case, which turned out to be 5 weeks. And so that's going to be one of the points for appeal here, is that we didn't have a chance to talk to these people. So I didn't get at that at all. In R. Kelly, and to me this was the most significant part of the case, which was done by a lawyer by the name of Ed Jensen, fabulous lawyer. He was the lead lawyer for 6 years. They just brought me in to do the opening, closing, and all of that because, let's face it, it was a racially sensitive case. It was a sexual case. They wanted a younger lawyer who could maybe not be blush when they talk about these type of things. But he sat down, and then we did it witness by witness by witness. And he's a genius. And the reason Ed Jensen is a genius is because he's probably one of the most insecure people I've ever met in my entire life. And he'll admit that. But what that is he has spent his entire career, his entire life, looking at people and knowing what they want to hear, knowing what they like in himself. And then he'll change whatever it is of himself to meet those expectations. And he's a genius at that. And I watched him juror by juror by juror, talked to each one, and every time he did it, he changed whatever it was, and they loved him. And at least my theory in trying cases are, if a jury loves you and likes your client, they will find a way to help you. And Jensen was a genius, and he picked 12 people who were either blind or liked him. One of the two, since it was all on videotape. One of the two, they were either blind or just really liked him. And it was wonderful to watch that happen, and I didn't do anything in it. And that won the case because you had one of the greatest juries I'd ever seen, hand-picked by him. And so that's what I think. It was wonderful. And he'd take the high-profile stuff and made it seem like it wasn't important, and then took small points and built them up right there in voir dire. And so anybody out there, if you want a good jury, go to Jensen. He is the best that I have ever seen.
The judge in our case did a super job, quite frankly, I think, in the jury selection. It was a process that I wish more federal judges would do. You know, the frustration in trying federal cases is usually the lawyers have little or nothing to do with the jury selection, which is one reason I've always preferred to try cases in state court, where we do have some impact on it. But in this particular case, what Judge Walton did, he had a mixture that, because of the high publicity on individual cases, we wanted a jury that didn't know anything about baseball. Because, in all due respect to those of you out there that are baseball fans, true baseball fans are not well people. Okay? I have never gotten hate mail, and now, of course, email and text as vicious as I received for representing a ball player who was accused of putting something into his body. I've never seen anything like it. It just totally floored me. My secretary quit passing them on when they would come into our main email slot. So we decided early on, and we did a couple of focus groups to see, and it turned out to be true, that anybody that had a history of following baseball and all, they hated that subject so much, as far as they were concerned, everybody did it, and they were not going to listen to evidence. So we had a jury of 9 people that had never even heard of Roger Clemens, and the other people were not baseball fans. And it's one of the 2 best juries I've ever had. And a lot of it had to do with the process this judge allowed us to do. Well, first of all, they did the pre-screening, which I don't like, exactly as Sam's talking about. They only sent over people who said they could endure an 8 to 10 week trial. Well, how many people can that be? And in Washington, D.C., who's it going to be? It's going to be government employees or unemployed or just a small group of people or retired people, et cetera. So there was that screening process I was uncomfortable with. But because he allowed us to do the following, it worked wonderfully as far as we were concerned. He had a long questionnaire that we'd both put our input to, and he took some things and all, but it really was his creation. And then the jury brought in the panel, 100 people. They were set out there, and they were all given a sheet of paper with the numbers. And they would check the number as he read the question to them. He stood in the well, read out the question, 80-something questions, and he read the question, and each one of them was instructed to put a check mark on there if that question applied to them in any way. And then those sheets were collected, and we would start out trying to see if we could do 25 a day individually. And they would show. And we got a jury in, I think, 3 days. It took us 3 days, but that's not bad for that type of case. And what he would do then is he would bring the juror in individually, and then he would ask them, you say you marked number 1, why does that apply to you, et cetera. And then he would ask the lawyers. Now, he had in mind probably 2 to 3 minutes. He would let the lawyers follow up with questions. Well, you're giving all your, that kind, come on, all right? But it gave us an opportunity to get a feel for all of them individually. And we ended up with just a dynamite jury. We had 7 graduate degrees on that jury. I've never had that. And they were the most attentive thing. And the final thing I would recommend to all of you, he allowed the jury to ask questions. And it is like having a free shadow jury out in the audience, because you could tell what was happening going through the trial. And the way he would do it, I shout to I was opposed to it originally, but we didn't oppose it to him. But I mean, had reservations. I loved it, because what would happen is that he did not allow redirect. He didn't allow recross. Government's putting on their case. So direct, cross, redirect. No, Mr. Hardin, nothing further. Stop. Any of the jurors have any questions? The jurors would write out on a 3x5 card the clerk had given them their questions. She would collect it. And believe it or not, this didn't take long at all. It really did not stretch this trial out. And then she would take him up to the bench. We would approach the bench. He would put on the white noise. The jury couldn't hear. One juror started bringing a book, and when the white noise went on, started reading his book. And so then he'd read the question to us, and we'd object or not object. Say, and then when it happens, he'd read them. This jury, when the first main agent testified, a guy named Nowitzki, who's made it his life work to mess with this, they had 29 questions for him. One of which was, I had been saying since opening, and you get an idea as to whether what you're saying. I had been saying that this was, not just overkill, but essentially the government had cut a deal with a person that they had decided was dealing drugs and required him to testify to a private law firm investigating for a private company as a condition of not being charged with a federal crime. And one of the questions was do you think perhaps you have overstepped in this case? That question was not asked, but it sure was nice to know. When the government put their physical evidence in that was supposed to be such a problem, there were 32 questions, and they were very, very good questions. When this thing was going on, my favorite question probably is to the main accuser that was not also was not asked by the judge is, in light of all the lies you've told, why should we believe you? But the jury selection process he did, I loved. I mean, it really, really combined, and it can be done in a way that doesn't take that much time.
Most studies that have looked into this say that jurors today are not following the prescription of the judge not to be looking at the media. In particular, they're going on the web, they're texting their friends on their phones, and I just wonder for each of you whether that alters the way you handle the trial or your interaction with the jurors.
All right, I said I was going to tell the truth. All right.
For the fourth time.
For the fourth time. Yes. One of the things that I have a guy that's charged with attempt murder in one case and then an armed robbery on another case. The armed robbery actually came first from 2008. He's charged in 2009. It's now 2012. They're going on the attempt murder first. Our defense is self-defense. That the guys that ended up shot, one shot in the leg, one shot in the hand. There were 5 people out there, 4 against my client. Gang stuff in Chicago. I went on right before trial onto Facebook. I got my 5-year-old son to teach me how, and I got on Facebook and I started looking up the names, and sure enough, the main guy who was shot in the leg, who says my client was just walked over to him and just shot him for no reason, was throwing up pitchforks, had gang signs, tattoos, had pictures of himself up there with the other guys in there, gang banging. Then I looked up the next guy, and sure enough, the next guy doesn't have a puppy. I couldn't believe this. A puppy and a gun, and the gun to the puppy's head. I see. It's amazing. Anybody who shoots a human, everybody, oh, okay. But you shoot a dog, forget it. You know. But that's the reaction I knew. If I showed a puppy being shot to this jury, forget it. But I also knew I was going to have to use those terms. Isn't this your Facebook page? Isn't this? And you know what's going to. I mean, we all know. So certainly, I remember there was a person in the Illinois State Police Crime Lab by the name of Pamela Fish who had been charged with actually falsifying DNA and been kicked out, been charged with falsifying DNA in these cases. Well, that was about 10, 15 years ago. I get a case in which it was an old one. They finally do the DNA, and it comes up. Well, she had done the original. And so I spent my entire time asking every lab technician, you know about Pamela Fish, don't you? No, you don't remember her? Well, have you ever Googled her? Have you ever Yahooed her name? You know? And so, look, the judge tells them what to do. My job is to put it out there. And so that's what you do. So it does. We're in a technological savvy world, and you got to try to take advantage of what you can in an ethical way. I didn't tell them to look them up. If they do, that's on them.
I color me naive. I really, in talking to the jurors, I mean, I had back a number of years ago, my favorite story about a juror following the judge's instructions is that I represented the estate that Anna Nicole Smith was trying to get the money from, and it lasted for years. But during the trial, which was a 5.5-month trial, I found out that one of the women jurors had her husband put each day's newspaper that had anything about it in the trunk of his car. And so they had to finally start doing a second car because it was 5.5-month trunk. But she had him keep all the newspapers in her trunk that she could read after the trial was over. And my experience has been a little bit different. I know the studies say that. I'm deathly afraid of people doing that. But I'm always amazed on the other side of how many jurors do not do it. And so about the only concession I make to it is not let there be seen any public image during the trial that in case they did watch TV or whatever, we could be criticized for. So we would never be smiling seen with the cameras out there leaving the courtroom. We would never be seen smiling coming into the courtroom. I don't want the jury to think we took it lightly. I had the advantage of a gag order, so none of us were talking to the media. But to show you just how conscientious they are, but then the jury, I've gotten emails. I still hear from some of the jurors with text and emails after the trial, and I'm satisfied those people weren't doing it. And they told me later about the deliberations. They did not know until they started deliberations the second day. The first day they pick the form and they go home and they come back the next day. They truly didn't have any idea how anybody on the jury felt about the case individually until they started deliberating. And finally, just as a caveat of people being concerned about the government these days, they told me also they took a vote in the jury room after they were unanimous, not guilty on every single count. They never had a split vote on all 14 that were left after we got thrown out of the obstructive acts, and on perjury and the others. The first vote they ever took on each thing was always unanimously not guilty. So it was not a split jury. But they then voted they would not talk to the media, and they haven't. And the reason they weren't, they said if the government can do to Roger Clemens with his money and his position, with IRS and FBI agents and everything, what they did to him, what could they do to us if we are quoted in the paper saying what we really thought about what they did? So they have never talked to the media. But that's a horrible commentary. And one final thing about this is, and this is why I really don't believe they were looking at anything before. They had no idea. They were learning everything through the trial. But one woman told me, an African-American woman, probably about 60, 65 years old, one of the jurors, delightful woman. She says, you know, Rusty, they talked about protecting the children with drugs and stuff. The Congress wanted to talk about that. You know what they really taught kids with the Roger Clemens case is, if your Congress calls you, take the fifth. And isn't that a horrible, she said, isn't that a horrible lesson to be teaching people? And she said it, this guy was prosecuted because he wasn't willing to take the fifth. And what does that tell our kids?
I want to leave a few minutes for questions. Let me just give you, Sam, 2 minutes to tell us what you think happened badly or well in the second trial that you did not handle.
Well, my father and I were intimately involved with the second trial, and all I can tell you is it was a one-sided affair. Many times one of the things that came out that the governor was going to testify, the reason he was going to testify was he was guaranteed he'd be able to play, I think it was either 24 or 27 of his own tapes. The minute he hits the stand and the government objected, the judge he said, I've reconsidered my ruling, you get to play one. And so, I mean, it really was. They weren't allowed, the government had narrowed their case, and they weren't allowed to bring out all kinds of facts. It really honestly was a one-sided affair. And the appeal in this case, I think, is going to be very successful because of that. He was not even allowed to say, listen, I thought this was legal. He was prevented from saying, what I didn't think was illegal. This is why. The judge prevented him from doing that. Now, one of the things the United States Supreme Court's been very good, and the Seventh Circuit has been very good on, is that the defendant has a right to present his defense. If he can't say, I thought this was legal and this is why, that was his entire defense. The whole case came down to intent. Did you intend to sell a Senate seat? We know no money changed hands, and between he and Jesse Jackson Jr., there was no conversation regarding the Senate seat itself other than Jesse Jackson Jr. said he wanted it, and the governor said, well, will you do my health care? And he said no. surprisingly. And so we knew that. So it came down to his entire intent. And so that's the difference between, I think, the first trial and the second trial. The first trial, the government was much more overly confident. They thought my father and I were, and I put this is right in one of the articles, were just clowns. They really thought that we were going to come in there. Anybody who's familiar with Chicago, the state court is 26th in California. That we were just 26th in California street hustling lawyers. While that might be true. But my father had been in federal court hundreds of times, and they weren't prepared for that. The second time they narrowed it and then got the judge to make rulings that simply were not fair. And I honestly predict that this will either be overturned or his sentence reduced considerably.
Okay, so I don't think we have time for questions, so I apologize for that. But please join me in thanking Rusty Hardin and Sam Adam. Great job.